take a few minutes to talk about the President's nominee for Secretary of Labor, Tom Perez. I've already spoken on Mr. Perez over the last few weeks, and I will not repeat everything I said, but it's important for my colleagues to understand the basis of my opposition. We've had a lot of debate around here over the last few days about what grounds are appropriate to oppose an executive branch nominee. Many of my colleagues have suggested that senators should not vote against such a nominee based on disagreement over policy. That may or not be the appropriate view, but I'm not going to get into that debate today. I'm quite sure that I would disagree with Mr. Perez on a host of policy issues, but I want to make clear to my colleagues, those policy differences are not the reason I'm vigorously opposed to this nominee. I'm opposed to Mr. Perez because the record he has established to government service demonstrates that he is willing to use the levers of government power to manipulate the law in order to advance a political agenda. Several of my colleagues cited examples of his track record in this regard. But in my view, perhaps the most alarming example of Mr. Perez's willingness to manipulate the rule of law is his involvement in the quid pro quo between the City of St. Paul and the Department of Justice. In this deal, the Department of Justice cut with the City of St. Paul. The department agreed not to join 2 False Claims Act cases in exchange for the City of St. Paul withdrawing its case before the Supreme Court in a case called Magner v. Gallagher. Mr. Perez's actions in this case are extremely troubling for a number of reasons. At this point, no one disputes the fact that Mr. Perez actually orchestrated this entire arrangement. He manipulated the Supreme Court docket so that his favored legal theory, called disparate impact theory, would evade review by this high court. In the process, Mr. Perez left a whistleblower twisting in the wind. Those are the facts, and even Mr. Perez doesn't dispute them. The fact that Mr. Perez struck a deal that potentially squandered up to $200 million taxpayer dollars in order to preserve a disparate impact theory that he favored is, of course, extremely troubling in and of itself. But in addition to that underlying quid pro quo, the evidence uncovered in my investigation revealed Mr. Perez sought to cover up the facts that the exchange ever took place. And finally, let me emphasize that this should concern all of my colleagues when Mr. Perez testified under oath about the case, both to congressional investigators and during confirmation hearings. In those 2 instances, Mr. Perez told a different story. The fact of the matter is that the story Mr. Perez told is simply not supported by the evidence. Let me begin by reviewing briefly the underlying quid pro quo. In the fall of 2011, the Department of Justice was poised to join a False Claims Act lawsuit against the City of St. Paul. That's where the $200 million comes in. That's what was expected to be recovered. The career lawyers in the U.S. Attorney's Office in Minnesota were recommending Department of Justice join the case. The career lawyers in the Civil Division of Department of Justice were recommending the department join the case, and the career lawyers in the Department of Housing and Urban Development were recommending that Justice join the case. So at that point, all of the relevant components of government believed that this case was a very good case. They considered the case on the merits, and they supported moving forward. or as one of the line attorneys wrote in an email in October 2011, quote, "looked like everyone is on board," end of quote. But of course, this was all before Mr. Perez got involved. Now, at about the same time, the Supreme Court agreed to hear the case called Magner v. Gallagher. In Magner, the city of St. Paul was challenging the use of disparate impact theory under the Fair Housing Act. The disparate impact theory is the mechanism Mr. Perez and the Civil Rights Division were using in lawsuits against banks for their lending practices. For instance, during this time period, Mr. Perez and Justice Department were suing Countrywide for its lending practices based upon disparate impact analysis. In fact, in December 2011, the department announced that it reached a $355 million settlement with Countrywide. And again, in July 2012, Department of Justice announced a $175 million settlement with Wells Fargo, addressing fair lending claims based upon that same disparate impact analysis. And of course, there are a string of additional examples, but I don't need to recite them here. But what is clear is that if that theory were undermined by the Supreme Court, it would likely spell trouble for Mr. Perez's lawsuits against the banks. So Mr. Perez approached the lawyers handling the Magner case, and quite simply, he cut a deal. The Department of Justice agreed not to join two False Claims Act cases in exchange for the city of St. Paul withdrawing Magner from the Supreme Court. Now, you've got interfering in the agenda of the Supreme Court. At the same time, a deal is going to cut the taxpayers out of winning back $200 million under the False Claims Act. In early February 2012, Mr. Perez flew to St. Paul, and he flew there solely to finalize the deal. The next week, Justice Department declined to join the first False Claims Act called the Newell case. The next day, City of St. Paul kept their end of the bargain and withdrew the Magner case from the Supreme Court. Now, there are a couple aspects about this deal that I want to emphasize for my colleagues. First, as I mentioned, the evidence makes clear that Mr. Perez took steps to cover up the fact that he had bartered away the False Claims Act cases and the $200 million. On January the 10th, 2012, Mr. Perez called the line attorney in the U.S. Attorney's Office regarding the memo in the Newell case. Newell was the case that these same career attorneys that I referred to and quoted previously were strongly recommending the United States join. Now, all before Mr. Perez got involved. Mr. Perez called the line attorney and instructed him not to discuss the Magner case in the memo that he prepared outlining the reasons for the decisions not to join the case. And here is what Mr. Perez said on that call. Quote, "Hey, Greg, this is Tom Perez calling you at 9 o'clock on Tuesday. I got your message. The main thing I want to ask you, I spoke to some folks in the civil division yesterday and wanted to make sure that the declination memo that you sent to the civil division, and I'm sure it probably already does this, but it doesn't make any mention of the Magner case. It is just a memo on the merits of the two cases that are under review in the key TAM context," end of quote. So it's pretty clear that they didn't want anything in writing that led people to believe that there was any deal being made. Now, after that telephone message was left, Approximately 1 hour later, Mr. Perez sent Mr. Brooker a follow-up email writing, quote, "I left a detailed voicemail. Call me if you can after you have a chance to review the voicemail," end of quote. Then several hours later, Mr. Perez sent another follow-up email writing, quote, "Were you able to listen to my message? Question mark, end of quote. Now, Mr. Perez's voicemail was quite clear and obvious. It told Mr. Brooker, quote, "Make sure that the declination memo doesn't make any mention of the Magner case. It is just a memo on the merits of the two cases," end of quote. So very clear. It couldn't be more clear, in fact, that this was an effort, that no paper trail that there was ever any deal made. Yet, when congressional investigators asked Mr. Perez why he left the voicemail, he told an entirely different story. Here's what he told investigators, quote, "What I meant to communicate was, it is time to bring this to closure. And if the only issue that is standing in the way is how you talk about Magner, then don't talk about it," end of quote. But anyone who actually listens to the voicemail knows that this is just plainly not what he said in that voicemail. He didn't say anything about being concerned with the delay. He said, quote, "Make sure you don't mention Magner. It is just a memo on the merits." His intent was crystal clear. Mr. Perez also testified that Mr. Brooker called him back the next day and refused to omit the discussion of Magner. Now let's applaud that civil servant, because he isn't going to play that game. And according to Mr. Perez, he told Mr. Brooker during this call to follow the normal process. But again, this story is just not supported by the evidence. 1 month later, after Mr. Perez flew to Minnesota to personally seal the deal with the city, a line attorney in the civil division emailed his superior to outline the quote, unquote, additional facts about the deal. Point 6 read, quote, USAMN, and that stands for U.S. Attorney, Minnesota. So let me start over again. Quote, USAMN considers it, underlined, non-negotiable that its office will include the discussion of the Supreme Court case and the policy issues in the declination memo, end of quote. If Mr. Perez's story were true and the issue was resolved on January the 11th, then why, 1 month later, would the U.S. Attorney's Office need to emphatically state that it would not hide the fact that the exchange took place? Now, as I just mentioned, Mr. Perez flew to Minneapolis to finalize the deal on February the 3rd. And you would think, wouldn't you, that a deal of this magnitude would be written down so that the parties understood exactly what each side agreed to. But was this agreement written down? No, it wasn't. After Mr. Perez finalized the deal, the career attorneys asked if there was going to be a written agreement. What was Mr. Perez's response? He said, quote, no, just oral discussions. Word was your bond, end of quote. So let me just review. At this point, Mr. Perez had just orchestrated a deal where the United States declined to join a case worth up to $200 million of taxpayers' money in exchange for the city of St. Paul withdrawing a case from the Supreme Court. And when the career lawyers asked if this deal will be written down, he said, quote, no, your word was your bond, end of quote. Of course, the reason you make agreements like this in writing is so that there is no disagreement down the road about what the parties agreed to. And as it turns out, there was in fact a disagreement about the terms of this unwritten deal. The lawyer for the city, that's Mr. Lillehaug, told congressional investigators that on January 9th, approximately 1 month before the deal was finalized, Mr. Perez had assured him that, quote, HUD would be helpful, end of quote, if the Newell case proceeded after the Department of Justice declined to intervene. Mr. Lillehaug also told investigators that on February 4, the day after they finalized the deal, Mr. Perez told him that HUD had begun assembling information to assist the city in a motion to dismiss the Newell complaint on quote unquote original source grounds. But according to Mr. Lillehaug, this assistance disappeared after the lawyers in the civil division learned of it. Now, why is that significant? Mr. Perez represents the United States. He represents the American people. Now, this Mr. Newell, the whistleblower, is bringing a case on behalf of the United States and indirectly the people. Mr. Perez is talking to the lawyers on the other side, and he tells the people, in essence, after the United States declines to join the case, we will give you information to help you defeat Mr. Newell, who is bringing the case on behalf of the United States. Let me say that a different way. In effect, Mr. Perez is offering to give the other side information to help defeat his own client. Now, is that the way you represent the American people? And you're working for the American people. Mr. Perez was asked about this under oath. Mr. Perez told congressional investigators, quote, "No, I don't recall ever suggesting that," end of quote. So on the one hand, we have Mr. Lillehaug, who says Mr. Perez made this offer first in January and then again on February 4, but the assistance disappeared after the lawyers in the civil division caught wind of it. On the other hand is Mr. Perez, who testified under oath, quote, "I don't recall," end of quote, ever making such an offer. Who should we believe? The documents support Mr. Lillehaug's version of the event. On February the 7th, a line attorney sent an email to the director of civil fraud section and relayed a conversation a line attorney in Minnesota had with Mr. Lillehaug. According to Mr. Lillehaug, the line attorney wrote, there were 2 additional items that were part of the deal. And one of those 2 items was this, quote, HUD will provide material to the city in support of their motion to dismiss the original source grounds, end of quote. Internal emails show that when the career lawyers learned of this promise, they strongly disagreed with it, and they conveyed their concern to Tony West, head of the civil division. During his transcribed interviews, Mr. West testified that it would have been, quote unquote, inappropriate to provide this material outside of the normal discovery channels. Mr. West said, quote, I just know that that wasn't going to happen, and it didn't happen, end of quote. In other words, when the lawyers at the civil division learned of this offer, they shut it down. Again, why is this important? It is important because it demonstrates that the documentary evidence shows the events transpired exactly as Mr. Lillyhog said they did. Mr. Perez offered to provide the other side with information that would help them defeat Mr. Newell, in this case, on behalf of the United States. In my opinion, this is simply stunning. Mr. Perez represents the United States. Any lawyer would tell you it is highly inappropriate to offer to help the other side defeat their own client. This brings me to my final 2 points that I want to highlight for my colleagues. Even though the department traded away Mr. Newell's case and $200 million, Mr. Perez has defended his actions in part by claiming that Mr. Newell still had his day in court. What Mr. Perez omits from his story is that Mr. Newell's case was dismissed precisely because the United States would not continue to be a party and would not be a party. After the United States declined to join the case, the judge dismissed Mr. Newell's case based upon, quote unquote, the public disclosure bar, finding that he was not the original source of information to the government. I'll remind my colleagues, we amended the False Claims Act several years ago precisely to prevent an outcome like this. Specifically, the amendments made clear that the Justice Department can contest the original source dismissal even if it fails to intervene, as it did in this case. So the department didn't merely decline to intervene, which is bad enough, but in fact it affirmatively chose to leave Mr. Newell all alone in this case. And of course, that was the whole point. That is why it was so important for the city of St. Paul to make sure that the United States did not join the case. That is why the city was willing to trade away a strong case before the Supreme Court and cut the taxpayers out of $200. In the process, when this case doesn't go forward, you cut the taxpayers out of $200 million. The city knew that if the United States joined the action, the case would almost certainly not go forward. I said that wrong, I'm sorry. The city knew that if the United States joined the action, the case would almost certainly go forward. Conversely, the city knew that if the United States did not join the case and chose not to contest the original source, it would likely get dismissed. The department traded away a case worth millions of taxpayers' dollars. They did it precisely because of the impact the decision would have on the litigation. They knew that as a result of their decision, the whole whistleblower would get dismissed based upon original source grounds, since the department didn't contest it. And not only that, Mr. Perez went so far as to offer to provide documents to the other side that would help them defeat Mr. Newell in his case on behalf of Mr. Perez's client, the United States. So now that's really looking out for the taxpayers. How would you like to have a lawyer like that defending you in some death penalty case? And yet when the Congress starts asking questions, they have the guts to say, quote, we didn't do anything improper about Mr. Newell, or, quote, we didn't do anything improper because Mr. Newell still had his day in court. Well, Mr. Newell, end of quote. Mr. Newell didn't have his day in court because the success of that $200 million case was dependent upon the United States staying in it. Now, this brings me to my last point on the substance of this matter, and that has to do with the strength of the case. Throughout our investigation, the department has tried to defend Mr. Perez's action by claiming that the case was marginal and weak. Once again, however, the documents tell a far different story. Before Mr. Perez got involved, the career lawyers at the department wrote a memo recommending intervention in the case.
In that memo, they described St. Paul's actions as, quote, a particularly egregious example of false certification, end of quote. In fact, the career lawyers in Minnesota felt so strongly about the case that they took the unusual step of flying to Washington, D.C. to meet with officials in the Department of Housing and Urban Development. And Housing and Urban Development, of course, agreed that the United States should intervene in this false claims case. But of course, that was all before Mr. Perez got involved. The documents make clear that career lawyers considered it a strong case, but the department has claimed that Mike Hertz, the department's expert on the False Claims Act, considered it a weak case. In fact, during his confirmation hearing, Mr. Perez testified before my colleagues on the Senate Help Committee that Mr. Hertz, quote, had a very immediate and visceral reaction that it was a weak case, end of quote. But once again, the documents tell a much different story than was told to members of the Senate. Mr. Hertz knew about the case in November 2011. 2 months later, a department official took notes of a meeting where the quid pro quo was discussed. The official wrote down Mr. Hertz's reaction. She wrote, quote, Mike, odd, looks like buying off St. Paul. Should be whether there are legit reasons to decline as to past practice, end of quote. The next day, the same official emailed the Associate Attorney General and said, quote, Mike Hertz brought up the St. Paul disparate impact case in which the Solicitor General just filed an amicus brief in the Supreme Court. He's concerned about the recommendation that we decline to interview in 2 qui tam cases against St. Paul, end of quote. These documents appear to show that Mr. Hertz's primary concern was not the strength of the case, as Mr. Perez led my Senate colleagues to believe. Mr. Hertz was concerned the quid pro quo Mr. Perez ultimately arranged was improper. Again, in his words, it, quote, looks like buying off St. Paul, end quote. Yet Mr. Perez led my colleagues on the Help Committee to believe that Mr. Hertz believed it was a bad case on the merits. So let me make one final point regarding process and why it is premature to even be having this debate. As of today, when we vote on Mr. Perez's nomination, we will be voting on a nominee who to date has not complied with a congressional subpoena compelling him to turn over certain documents to Congress. I'm referring to the fact that the House Oversight and Governmental Reform Committee subpoenaed emails from Mr. Perez. During the course of our investigation, we learned that Mr. Perez was routinely using his private email account to conduct government business, including business related to the quid pro quo. In fact, Department of Justice admitted that Mr. Perez had used his private email account approximately 1,200 times to conduct government business. After Mr. Perez refused to turn those documents over voluntarily, then the House Oversight Committee was forced to issue a subpoena. And yet today, Mr. Perez has refused to comply with the subpoena. Now here you got a person in the Justice Department doing all these bad things. People want him to be Secretary of Labor, and we're supposed to confirm somebody that won't respond to a subpoena for information that Congress is constitutionally entitled to. And we want him to be a Secretary of Labor when we have people come before Congress and say, yeah, we will respond to letters from Congress, will come up and testify. We're going to cooperate in the spirit of checks and balances. And then we got somebody before the Senate that won't even respond to a subpoena. So I find it quite troubling that this body would take this step and move forward with a nomination when the nominee simply refuses to comply with an outstanding subpoena. Can any of my colleagues recall an instance in the past when we were asked to confirm a nominee who would flatly refuse to comply with a congressional subpoena? Why would you want somebody in the cabinet thumbing their noses at the elected representatives of the people of this country that have the constitutional responsibility of checks and balances to make sure that the laws are faithfully executed? That's what they take an oath to do. It's quite extraordinary and should concern all of my colleagues, not just Republicans. My colleagues are well aware how I feel about the Whistleblower Protection Act. And my colleagues know how I feel about protecting whistleblowers who have courage to step forward, often at great risk to their careers. And this is about much more than whistleblowers, about the whistleblower who was left dangling by Mr. Perez. This is about the fact that Mr. Perez manipulated the rule of law in order to get a case removed from the Supreme Court docket. And this is about the fact that when Congress started asking questions about this case, and when Mr. Perez was called upon to offer his testimony under oath, he chose to tell a different story. And the unavoidable conclusion is that the story he told is not supported by the facts. And this is about the fact that we are about to confirm a nominee who, even as of today, is still thumbing his nose at Congress by refusing to comply with a congressional subpoena. I began by saying that although I disagree with Mr. Perez on a host of policy issues, that those disagreements are not the primary reason my colleagues should reject this nomination. We should reject this nomination because Mr. Perez manipulated the levers of power available to people in order to save a legal theory from Supreme Court review. Perhaps more importantly, when Mr. Perez was called upon to answer questions about his actions under oath, I do not believe he gave us a straight story. Finally, we should reject this nomination because Mr. Perez failed and refuses yet to comply with a congressional subpoena. For these reasons, I strongly oppose the nomination, and I urge my colleagues to do the same. And, Mr. President, I am complete. I've completed my statement.